Welcome to SCC Online. I am Syed Haroon, the Student Ambassador for Jamia Millia Islamia. And today we have with us Senior Advocate Rebecca Mammen John. Rebecca John is a name that does not require an introduction. Her feats in legal profession is enough to light up the sky. She is the first woman to be designated as a senior counsel by the High Court of Delhi. A graduate of Delhi University's prestigious Faculty of Law, Ms. John has been practicing law since 1988. Her decades-long practice has played an important role in molding the criminal jurisprudence in India, and her portfolio includes representations of the Talwar parents in the Arushi Talwar case, the stockbroker Harshad Mehta, cricketer S. Srishant, victims of anti-Sikh riot, victims of Hashimpura massacre, and more recently, Ms. Priya Ramani in the defamation case. Today, we are in conversation with Senior Advocate Rebecca John on her journey of criminal jurisprudence in India with respect to contemporary era. So without further delay, let's continue with Senior Advocate Rebecca John. Ma'am, at the outset, a very heartiest congratulations for yet another remarkable victory, which was frankly long due and the bare minimum one could expect from a progressive judicial system. Which brings me to the first question, which is on your practice in criminal law spanning decades. Have you seen a paradigm shift on how offenses relating to women and children have been treated by courts, and whether this change that we've seen now is sufficient, or is it still far from enough?
My answer is mixed. I have seen a paradigm shift. Don't forget that the Mathura judgment, which was a highly regressive judgment, led to the first set of criminal law amendments in the IPC and the CRPC in the 1980s. Yes. But it was a consequence of societal outrage, in particular when 5 law professors of the Delhi University wrote an open letter to the Supreme Court. Yeah. Subsequently, I have seen many important amendments with respect to the dowry prohibition, as well as Section 304B, which was introduced, and then, of course, the amendments made in 2013, both with respect to the IPC and the manner in which rape is to be perceived in India, as also with the introduction of the Sexual Harassment at the Work Prevention Prohibition at the Workplace Act. However, with respect to courts, it's been victory sometimes and defeat at other times. So while generally our courts have been very progressive about rights of women, we've also seen moments when very many judgments have been passed which are extremely regressive. So I don't think we've reached the stage where there is consistency in the manner in which courts treat these offenses. And I hope over the next few years that consistency can be achieved, both in terms of understanding the offense and the application of the law.
Indeed, ma'am. Indeed, it's actually a huge image that we see for the judgment that came last month, and few orders of the court, or few court proceedings that we hear even from the Supreme Court, which are very regressive.
Yes.
And frankly, while going through the Priya Ramani ma'am's judgment, we see respected ACMM's Ravindra Kumar Pandey's progressive remarks that wherein he specifically quoted that the sexual abuse takes away the dignity and self-confidence, and the rights and reputation cannot be protected at the cost of right to dignity. How do you see the country's legal system is adapting to the said judgment, and how will it pave a positive way forward?
Well, firstly, it's a judgment by a judge of the lower judiciary. And therefore you must celebrate that judgment, because he's not a constitutional court. He's not a court of record. So therefore it can't act as a precedent in any other case, because only judgments of constitutional courts can act as precedents. However, it can have persuasive value in the way judges in other courts look at offenses of this nature. But I will like to add that the judgment of the learned ACMM was passed in the context of Priya Ramani's case. Don't forget that Priya Ramani was an accused in that case, in which she was accused of defamation, and where she had taken a specific defense, a statutory defense, which is available under Section 499, which is Exception 1, Exception 9, and Exception 3, truth made in public interest and for public good. And she set about proving that defense. So I don't think we should take a very simplistic view of the judgment. The judgment was naturally written in the facts and circumstances of Priya Ramani's case.
Indeed, so there's still a long way ahead.
Yes.
Which brings me actually to the next question. With the start of MeToo movement back in 2017, 2018, and that MeToo movement in India has ushered significant change in the society for quite some time now, and has remarkably influenced the feminist jurisprudence, especially in India, and its interpretation thereof. Yet we see, such as the case of Ms. Priya Ramani, that there are several defamation cases against various victims of sexual harassment who have finally summoned up the courage to speak up. Furthermore, is there any manner in which the molester kid can be brought to justice, and despite the severe delay in filing the FIRs or conduction of the MLCs?
So I think the MeToo platform was not really a platform where women wanted necessarily to access the criminal justice system. It was a platform which was started internationally, first in America, moved to other countries, then came to India, where women used that platform to talk about incidents of sexual harassment, sometimes even sexual assault, which they faced at the workplace. I don't think most of the women who made those disclosures on the platform were interested in criminal prosecution. And this is perhaps a reflection of our own criminal justice system, where women have to wait years before any kind of redressal is given to them. And therefore, they use this platform to call out male bosses who had sexually harassed them. So I think the MeToo platform has to be looked at very differently. And the women who made allegations were not necessarily interested in taking it forward in terms of a criminal prosecution.
Okay. Yeah, but when we see for few women who proceed to go forward with criminal litigation, that they file an FIR. So we have observed specifically in the rural areas, even while I was interning here and other places, I saw that police in rural areas generally refuse to file an FIR or on sexual offences, on matters relating to sexual offences, especially if the accused is well connected to the higher society, or if the victim does not have adequate legal representation. And these offences obviously are cognizable, and these offences are going against the judgment of Lalita Kumari versus State of UP. What can be done to correct the system?
So these are systemic changes, and a judgment here or a judgment there is not going to change the systemic problems that exist. There is a problem of language. The commonplace language used against women is so violent, is full of abuse, is so misogynistic. Don't look at the police or the judiciary as having an understanding that common people, that you and I, don't have. It is the same language which percolates down to different wings of the police, and even perhaps in the judiciary. So I think we need to have a better understanding of these offences, and we can have a better understanding of these offences only if we ourselves use language which is respectful within our homes, firstly, as a starting point, where we don't treat our sons differently from our daughters, on the streets, where we do not harass women who are occupying the same streets as men, in the workplace, where women are treated with the same dignity as men. So I think you're looking at making societal changes, and it would be a very simplistic way of looking at it if we only look at this through the prism of Lalita Kumari's judgment. Yes, the police does not register complaints. But that comes from the same misogyny. It comes from the same ecosystem that they are part of, because they don't think that this is worthy of making a complaint. And I think unless that ecosystem changes, we really can't expect any miraculous change in the way the police conducts itself. And so you can have laws which say that the minute a cognizable offence is disclosed, you must register an FIR. But who is to understand that law and who is to apply that law is a question that you and I need to ask. As I say, beyond a point, laws, judgments will have limited impact till such time that we do not change ourselves and the way we look at women.
Okay, so it's more of an individualistic approach.
It is more of a societal community approach to the way we treat women. And as you very rightly use the word, rural, semi-rural areas. While Priya Ramani's judgment must be celebrated, we must never forget the struggles of women across this country who may not be from the same class as Priya Ramani, who do not have the financial means to fight cases, and whose stories are never heard simply because they come from depressed and vulnerable sections of society. So I think our celebration must be tempered, and we must look at this realistically, particularly when a large majority of Indian women are unable to access justice the way Priya Ramani could.
This just tells us how long a way it is for us to reach the position that we seek at this moment.
Yes.
And which brings me to a question of interpretation of law, which was recently Justice Pushpa Ganediwala's interpretation of the sexual assault under POCSO. The extent it was to an extent that even Justice Madan Lokur and the former Chief Justice of Bombay High Court criticized it openly, her interpretation of the sexual assault. Do you think such literal interpretation or strict interpretation is justified, or the courts must interpret such provisions liberally to assist the victims who have gone through a lot?
I don't think that interpretation can stand in any judicial interpretation. It wasn't a judicial interpretation. I think that interpretation was perverse, and therefore it was rightly stayed by the Supreme Court. So it's not a question of literal interpretation or non-literal interpretation. It was a perverse interpretation, and rightly the Supreme Court stayed the judgment on the mentioning of the Attorney General of India. I don't think the law gives a judge the liberty to make those kind of interpretations. Naturally, there was an outcry, and a very regressive judgment was stayed by the Supreme Court.
So we see that each day there's some regression, but we're still moving forward somehow.
Yes.
And that's the best thing we can do right now. Which brings me to the next question, that we see an exponential rise in the cases related to caste and religious violence again in the minorities in India, which is generally treated in an abhorrent manner by the authorities as well as the state. What, in your opinion, has led to this, and why?
Again, I think it is largely to do with the political ecosystem that we are living in. Which permits this kind of violence to take place with impunity. When you give impunity to people to act in a particular way, you will see an exponential rise of crimes against the sections of people you mentioned. If there is the political will to control these crimes, it will not happen. So clearly that is lacking. I, however, do see many attempts made by courts, particularly the Delhi High Court, in trying to seek explanations as to why people who should be punished are not punished, why as you just yesterday a bench of the Delhi High Court asked the Delhi police as to why information relating to a person's charge sheet was first circulated to the media even before a court took cognizance of the offence, and how it impacts the right of a person to a free and fair trial. So I am hoping that there will be sufficient judicial intervention, and that judicial intervention will stop or at least prevent this kind of mindless ecosystem from developing. I'm hoping that there will be restrictions on the rights of the police, and there will be some fear in society. It's something that I hope will happen, because that is what our constitution guarantees to every Indian citizen, and we are only seeking that constitution is upheld in letter and spirit.
Yeah. And this actually, your answer actually brings me to the next question, which is highly related to your answer, which is the recently Delhi High Court, working in the same manner as you described, relied on the report from journalist Mr. Ravish Kumar while granting bail to 3 accused in Delhi riots, wherein HMJ Suresh Kumar Kai rightly pointed out that the investigating agency seemed to concentrate only on one side of the building while deciding where the shots were fired and such things. In your decades-long practice, have you seen this as a trend wherein the investigation authorities are focusing on one side of the story and not the other, or is it a recent find?
The scale at which it is being done. I mean, you could have seen the off case where the investigating agency went after a particular person for no apparent reason.
Exactly.
I've seen that, but not in the scale in which it is being done today. And it where just one narrative is put across. I would suggest somewhat shamelessly, and I'm very, very relieved that courts are now looking at this and saying, what is this material? How can you rely on one side when very clearly there is another side to the story? And both the trial court and the Delhi High Court different benches of the Delhi High Court have been consistently granting relief to accused persons who have been incarcerated as a consequence of that single narrative. So I look forward to further judicial interventions where this narrative is smashed. But it is unfortunate that considering the number of cases that have been filed post the Delhi riots, most of them actually perpetrate the single narrative.
Indeed, and we saw similar narrative while we're dealing with the Tablighi Jamaat case, in which I have personally worked in this office, and I was amazed at how things have been going on in the country.
But in the end, all of them were acquitted, and therefore the system actually worked for them, and the system upheld the rule of law. So while there is a lot of reason to feel somewhat depressed with the environment we are living in at the moment, there are also these remarkable judgments across the country which came out, and which actually threw out the claims of the police and said this was completely based on no material, based on prejudice, based on zero evidence. And all of them were either discharged, or the proceedings were quashed, or if some of them decided to face trial, all of them were acquitted. So the narrative was smashed in the end.
Indeed. What we have to follow is the famous lines that "Sitaron ke aage jahan aur bhi hain."
That's right.
Yeah. So, which brings me to my next question. It is the questions on bail, or in the current, a few months back, or what we see today. So, it is a common knowledge that bail is a rule and jail is an exception. However, we have seen that the recent trend in which the bail is denied to many students, activists, and protesters, on whom FIRs have been filed on very vague and inexplicable grounds. What are your views in this matter?
I've said this often enough, that the jurisprudence that Justice Krishna Iyer and judges before him laid down for this country, that bail is the rule and jail is the exception, is the jurisprudence on which India's constitutional values have been founded. You cannot pronounce someone guilty till he is actually found to be guilty of the offence. The prosecution must prove its case, not the defence. These are elementary foundations of criminal jurisprudence, and this is the basis on which criminal jurisprudence in this country has survived for 70 odd years. I find the increasing trend of arresting people without any material, purely on an accusation which even the police has not investigated, very, very disturbing. And I find the increasing trend of arresting young people even more disturbing. I think at some stage our courts have to take a more proactive, notice of these facts. You can't go after your youngest citizens in this manner on the basis of some remote peripheral allegations, which allegations may not even stick at the end of a trial. The power of arrest must be used with circumspection and with care. You cannot go and arrest people with little or no material backing you. Secondly, if arrested, the power of bail must be used liberally by courts. I am not saying that if someone is accused of a heinous crime and there is sufficient evidence to show that he or she committed that crime, that person must be granted bail. But a lot of these offences for which people are being arrested today are not offences where any physical act has been committed, but these people are being arrested for some thought they had in their mind, or something they wrote, or something they spoke. And neither the thought, nor the speech, nor the written script actually instigated any violence. And in the absence of that, to arrest people and to put them in continued incarceration for months and years on end is very, very sad. And I hope this jurisprudence that we created and of which we are so proud of is reinstated, both in the minds of individual citizens, but more importantly, it must be reinstated by courts, and a strong message should be sent out that bail and not jail is a foundation of criminal jurisprudence in India.
Yes, ma'am. And this brings me to one of the very underlying questions after this, which is the next step. If someone is not granted bail, they are sent to the custody of either judicial custody or custody. What happens then is we have also seen a trend wherein the basic human rights, basic commodities are not given to the person for when it comes to even medical assistance or basic things that one needs while he or she is in a custody. How do you see this is working on breaking the spines of those people, or how legal is this?
Obviously, it's completely illegal. But I also think that the legal community, which includes lawyers like me, must step up, and must bring to the notice of the court every kind of aberration which a person is subjected to. Human dignity must never be compromised at any cost, and every individual, howsoever heinous may be the crime, is entitled to all the protections available under Articles 21 and 22 of the Constitution. So I also believe that lawyers like us must step up and must ensure that crimes of this kind, custodial crimes of this nature, are brought to the notice of the court. We extract orders from the court by pursuing relief that such a person should not have been or cannot have been subjected to any kind of custodial violence. So it's going to be a Herculean task, but it is not an unachievable task. We have one of the finest constitutions in the world. We have laws which are progressive. We have a history of jurisprudence which is very, very progressive. we seem to have taken a small nap. We need to come out of that. But I'm hopeful that over a period of time, it will be realized that these measures will ultimately affect each one of us. And unless we accord protections which are available in law, none of us are safe.
And coming to my next question is on the recent judgment or recent case of Mr. Arnab Goswami, who's also a very renowned journalist, and who we have seen that the Bombay High Court dismissed Mr. Goswami's writ petition and granted liberty to approach the court via regular bail under Section 439 of the CRPC. However, the Supreme Court, with an alarming alacrity, allowed Arnab Goswami's bail under Article 32 of the Constitution of India, and even when the regular bail proceedings were pending in the Sessions Court, and this was directed by the Bombay High Court that the bail proceedings be disposed of swiftly. How procedurally consistent or legal was such an order by the Supreme Court of India, and what impact on similar future litigation would it entail?
So I have no problems with the Arnab Goswami judgment. I think it's a very progressive judgment. I think Justice Chandrachud has laid down the extent of power that can be exercised in a writ jurisdiction. He has looked at in writ jurisdiction the scope and extent of the offence and whether the offence was made out or not. And there are many paragraphs in that judgment which are very, very progressive and entirely in tune with India's jurisprudence on the subject. My problem is that we selectively apply that law. And if that is the law of the land as laid down by the Supreme Court, then it must apply to X, Y, Z, whoever is seeking the protection of the law. Selective application of the law and the judgment is something which I have problems with. I have no problems with a court seeking to protect the rights of an individual citizen. Courts must work with speed and alacrity. Courts must come down heavily against investigating agencies who are seeking to arrest people on specious charges. But this kind of relief should not be limited to one person or to the favorites of any political regime.
Yeah.
That kind of relief must, and the speed with which that relief is granted must be available to every Indian citizen. Otherwise, I have no problems with the judgment of Arnab Goswami. I think it's a very fine judgment.
Indeed, ma'am. Yes, that is exactly the point wherein we have seen that in several other judgments, the Supreme Court has tried to regress the boundaries of Article 32 of the Constitution of India, and then we have seen such progressive judgments in which the Supreme Court has immediately taken up whatever has come in front of them and worked upon it, which is, if we remove the person in name here, is a very nice judgment. But then at the same time, we have seen that Supreme Court is always also, in many instances, have limited the scope of Article 32 of the Constitution of India. How does that balance?
So I'm saying we should use the judgment to remind the court that Article 32 was invoked.
Yeah.
Article 32 was invoked to grant protection to the accused. Article 32 was invoked to remind the High Court that its powers under 227 are wide and that it should exercise its powers in a way that will protect citizens from misuse of the law. So I personally feel that the judgment of Arnab Goswami has given us all
The power we need.
the fillip we need, and we must use it constantly to remind courts that this is the length and breadth of the power, and do not self-restrict that power when it comes to other citizens.
Indeed. This brings me to the next question, which is again on bail and remand, which is would be the meaning and legality of transit remand and transit remand bail, and additionally, it's how has your view on what is your view on the Disha Ravi's arrest and the authorities' sheer lack on non-compliance to the ratio of Arnesh Kumar's judgment?
So 2 or 3 things. Yeah, I think Disha Ravi has been granted bail, so we
Yes,
should
she has.
celebrate that through a very, very fine judgment, which pretty much puts to rest all the claims of the investigating agency. As I said earlier, we must be very, very careful before, simply because you have the power to arrest, you do not have to arrest. And police agencies must remind itself constantly that power, between the power to arrest and the actual arrest, there should be sufficient material before which you should exercise that power. Now, obviously, the material was very sketchy, and yet the police chose to exercise that power, for which it was adequately reprimanded in that bail order passed by the Delhi court a couple of days ago. As far as transit remand is concerned, you must remember that these were non-bailable sections. These were cognizable offences. And while there is a 2019 judgment of the Delhi High Court under which clearly the Delhi police operates, which says that as far as possible, when you're picking up someone outside the jurisdiction of the FIR, you must produce that person before the nearest magistrate where that person resides, take transit remand, and only then produce such person before the court of jurisdiction. And while taking transit remand, you must satisfy the transit remand court of all the case diaries and of the fact that you have a case for which you are seeking transit remand. And the transit remand court must apply its mind to the facts and circumstances of the case before deciding whether transit remand should be granted. But the Delhi High Court had underscored that this procedure must be followed as far as possible. I think the overriding section is section 57 of the CRPC, which says that you must produce the arrestee within 24 hours of arrest. So while the Delhi police may not have committed an illegality in not taking transit remand, it was propriety demanded that they should have sought transit remand, particularly when the person in question was a resident of Bangalore and not Delhi, and then produced her before the Delhi court. Now, having said all of which, and I think I've spoken about this in the past, what is a matter of concern was that the police did not seem to have adequate material to effect the arrest, and that is why within 8 days or so of her being in custody, the Delhi court granted her bail. So in a sense, we've seen highs and lows in that case, the low being the manner in which she was arrested, the high being the court effectively exercising its power of bail and releasing her on bail without an extended period of incarceration playing out. So ultimately, I think the law won.
Yeah, indeed, it did. And when this question, ultimately the law won, the statement arises another question: when the law is such which is made to curtail the freedoms of the citizens in the country. In fact, it is today that one of the retired justice of the Supreme Court, right, said that one such law, such as UAPA, should be repealed as it is used to restrain the people who are speaking up. How do you think the Indian government of any time would deal with such laws which are actually very regressive while maintaining the question of national interest and national security?
You know, I've always said that the IPC is more than equipped to deal with any situation. However, if you feel that you want to bring in a special anti-terror law to deal with specific acts of violence, which is in fact defined under Section 15 of the UAPA, then restrict it to that. Okay. However, you can't extend its scope to acts which are not at all violent, acts of dissent, and label people as urban Naxals or terrorists or sympathizers of a particular group of or section of people. I think the test of a robust democracy is how we treat our citizens, and diverse opinions, some opinions which may not be palatable to every one of us, should not be viewed as a threat. India is, at the end of the day, a diverse country with multiple states, union territories, multiple languages, multiple religions, ethnicities, and that is something we should celebrate and not condemn. So any kind of diverse opinion, if that is viewed as sedition or a threat to the state, then the state ends up looking very insecure. So acts like the UAPA, I believe, perpetrate violence. UAPA should not find its place in any civilized democracy, and it's time that we had a relook at it for specific acts of violence, which obviously has an effect on public order. You may go after such individuals who perpetrate that violence. I am not suggesting that people have any right to resort to violence, but healthy debates which doesn't really affect our national life or our national ethos must never be clamped down. And even if any government finds it unpalatable, listen to it. You want to consider it. You want to ignore it. But it doesn't need the heavy hand of law, and it certainly doesn't need some of this country's finest intellectuals to be in jail.
Indeed, that is very, very true. Which brings me to my last question, which is obviously your experience as a successful advocate in an abysmally high male-dominated profession, that is criminal litigation. And if you had to advise the upcoming female or transgender or any other person who's going to pursue criminal litigation in the future, or even in general students, what would your advice be to them?
Recognize your privilege. Although I am a woman practicing criminal law, which is essentially a male-dominated sphere, I am still privileged. I come from a urban English-speaking background, and unless I recognize that I was privileged, any advice given to anyone else would be meaningless. So I think each one of us must recognize our privilege, must always consider how other people in our country, in remote areas, are fighting multiple wars at the same time. The war of poverty, the war of inequality, the war against hunger, and therefore when a question like this is asked, yes, I survived as a criminal lawyer in a male-dominated profession, but that survival was nowhere near the daily acts of struggle and survival that so many of my fellow countrymen and women go through on a daily basis.
Indeed, that is very humble of you to say that, but I mean, even though it's true, it's very...
I think law teaches you compassion. I think, and I think it's also an inward journey where you are asked to introspect, and my response to this question, obviously, as a woman, I've had to deal with all manner of problems and all manner of discriminations. But I have no complaints because, as I said in the beginning, I came from a position of privilege, and that is not something that a large majority of Indian citizens can say. And therefore, despite despite being a woman in a male-dominated space, it's nothing compared to the daily struggles of fellow citizens, and therefore I don't think it's such a big deal.
Thank you so much for such a diverse and such a healthy discussion on all of these questions. I'm really thankful for you for giving us so much time and giving our viewers who would be watching us later on so much time.
And thank you very much. It's great to see young students, coming out like this. You're student ambassadors of SEC. It's wonderful to see all of you doing the work that you're doing. And really, I think the future is quite safe.
I really hope so. Thank you so much.
Thank you.